Welcome back to beautiful scenic Burlington. We're here at the Burlington Police Department. To do a reading from a 2019 Vermont Supreme Court case, Doyle versus City of Burlington Police Department. This case involves public records requests. Actually, let's get a little further from the road. So there'll be maybe less road noise. Doyle appeals the trial court's denial of his motion for partial judgment on the pleadings pursuant to Vermont Rule of Civil Procedure 12C. In his motion, plaintiff argues that the Burlington Police Department unlawfully withheld public records. Pause for flipping the page here. In violation of the Public Records Act, when it charged a fee for costs that would be incurred by complying with his request. Based on the plain language of the PRA, we hold that the BPD cannot charge for staff time spent in complying with requests to inspect public records. Accordingly, we reverse. Plaintiff stated the following facts in his complaint. Plaintiff witnessed an incident involving BPD officers in a public park. Shortly thereafter, plaintiff submitted a citizen's complaint form to the BPD to voice concerns about alleged officer misconduct and unreasonable use of force during the incident. Plaintiff subsequently requested to inspect body camera footage, among other records related to the incident. The BPD denied his request. Plaintiff appealed the denial to BPD Chief Brandon Del Pozo. In his response to the appeal, Chief Del Pozo characterized plaintiff's request as seeking to inspect records. He stated that, pursuant to statute, the BPD could only produce a heavily redacted form of the requested records, and the staff time to review and redact the records would cost plaintiff several $100s. Chief Del Pozo also informed plaintiff that he must pay a deposit before the BPD would begin reviewing and redacting the requested records. All right, I'm gonna skip forward a little bit. A lot of this case hinges on the distinction between requesting and copying. Inspecting and copying. We acknowledge that here, where no one disputes that the BPD must redact exempted material before producing the record for inspection, the BPD cannot comply with the inspection request without first creating a second redacted version of the requested material. See VSA 318E. In that situation, the BPD argues, the request to inspect is really a request for a copy. More generally, the BPD contends that the work involved in complying with a request determines whether a state agency may charge a fee for staff time, not a semantic distinction between inspection and copying. In support of its rationale, the BPD points to Herald Association versus Dean, in which we held that the PRA does not allow an agency to withhold public records simply because complying with the request is difficult or time-consuming. We held that the PRA provides a different remedy in those circumstances. The agency may charge and collect the cost of staff time associated with complying with a request for a copy of a public record. Herald Association is inapposite because it does not address a request for inspection. More importantly, as stated above, the statute's plain language indicates that the legislature did not intend to authorize charges associated with staff time in complying with a request to inspect. Where the meaning is clear, according to the plain language of the statute, we will enforce it according to its terms. State versus Richland, 2015. Furthermore, the PRA explicitly directs courts to liberally construe the Act to provide for free and open examination of records. The Act represents a strong policy favoring access to public documents. Schlansky v. City of Burlington, 2010. This policy is based on the legislature's acknowledgement that open access to governmental records is a fundamental precept of our society, and it is in the public interest to enable any person to review and criticize the decisions of officers of government who are trustees and servants of the people. Given this legislative policy, we should resolve any doubt in favor of disclosure. Sawyer v. Spalding, 2008. We note that both parties, as well as many of the amici curiae, raise competing policy concerns regarding their respective positions. These concerns cannot control our analysis. Our role is to interpret the law to give effect to the legislature's intent, not to impose our policy preferences on the public. McGough versus Acadia Insurance Company, 2011. We must accord deference to the policy choices made by the legislature. Badgley v. Walton, 2010, and enforce the statute according to its terms. Richland, 2015. Accordingly, we conclude that state agencies may not charge for staff time spent responding to requests to inspect public records pursuant to the PRA. We hold the trial court erred in denying plaintiff's motion for a partial judgment on the pleadings. Well, that's a little bit of case law and civics education for the people interested in making public records requests in Vermont. Goodbye from beautiful scenic Burlington.